Many thanks for that live update.
WESN.
With no ties to militant groups like Hamas or Islamic Jihad, a plan swiftly rejected by the Palestinian Authority. Reporting from Jerusalem, France 24's Andrew Hillier.
In the medium term, at least, this plan gives the IDF free rein to operate in the Gaza Strip until Hamas has been completely destroyed, and even beyond that, until the plan says all security threats have been removed. Now, in terms of who would run the Gaza Strip, the plan uses quite vague language. It says that civilian affairs will be run by local officials who, I quote, who don't have ties to countries or entities that support terrorism. The plan also moves forward with an Israeli government project to establish a security buffer zone on the Palestinian side of the border. Now that puts the Israeli government at odds with the Biden administration, which doesn't want any reduction in Palestinian land, bearing in mind that the Gaza Strip is already a tiny enclave. Another controversial part of this plan it would see UNRWA completely shut down in the Gaza Strip. The Israeli government says it wants to replace UNRWA, that's the UN relief agency for Palestinian refugees, with international aid agencies, but at this stage no specific mention of which aid agencies would step in to fill the void left by UNRWA if it were to be shut down.
And that was Andrew Hillier reporting. For the first time since Senegal's Constitutional Council rejected the term-limited president's bid to stay in power until the end of the year, Macky Sall spoke to journalists late on Thursday. He was proposed saying he would stick by his April 2nd date for leaving office as stipulated in the Constitution. However, he would not set a date for the presidential poll that was due to take place this month. He instead wants there to be a national dialogue. Well, this Friday, civil society organizations and 16 of the 21 candidates taking part in the presidential poll to succeed Sall have rejected this idea of a national dialogue. They want him to go on April 2nd and for a date to be fixed sooner than later. Sam Bradpiece is our correspondent in Dakar.
Well, the opposition have largely denounced Macky Sall's plan to hold a national dialogue, a step which the president says is absolutely necessary before a new election date can be unveiled. And many of the opposition candidates who were supposed to be running in the presidential election this Sunday have said they would refuse to participate. They accuse the president of essentially using the national dialogue as a way to buy more time in office, and their demand is that a new election date is fixed as soon as possible. As I already mentioned, this election was supposed to have been held this Sunday, but Macky Sall delayed the vote, citing accusations levelled at the Constitutional Council, accusations that many Senegalese people greeted with kind of incredulity, really. They just see it as a ploy.
WESN.
Well, this is 10 Questions. I'm Andy Johnson. Thanks for joining us. Thanks for being with us again here on the program. We want to discuss in this edition of the program, there have been two matters in the courts in the public sector. One in which an aspirant to the Trinidad and Tobago Police Service was denied entry because his height, it was said that he was too short, given police regulations. And in the other case, a prisons officer was allowed to, well, the judgment from the court was allowed to continue to wear his beard, whereas the authorities in the prisons were saying that that is not allowed. And those two matters raised questions about the Constitution. They were found to be unconstitutional. The question is, more and more, we find issues in the public domain in which the Constitution is called into play. It is said to be infringed in a number of respects. We want to talk about that. It's a sort of a growing trend, as it were, challenging decisions made in the public sector, in the public domain, that don't accord with what is said to be in the Constitution. So to help us understand some of that and to go forward with it, our friend and colleague around this place, Mr. Farid Ali, I would say a public issues attorney, quite apart from how he makes his bread and butter, but he's always there to try and help us out in these situations. Good to see you, my friend.
It's good to see you, Mr. Justin. Thank you for having me.
All right, let's on a broad scale, it seems as though more and more the society that we have will have to come to terms with what is in the Constitution, because the Constitution sort of upends a lot of what we knew to be the case, what we accepted to be the case. Either one of these two cases, we'll try and interrogate both of them. Because when I was growing up, you had to have some qualities, physical qualities, to be a police officer. And one expects is the same thing with the military. And if we go further than that, my sense is that issues about gender and equality and preference and so on will come to the fore when it comes to the extent to which those things now would be seen to be unconstitutional, whereas generations of us lived with accepting some of those things as the rules of the game.
Yeah. Well, if we were to understand the concept of a constitution, the British does not have an existing written constitution that they can turn to and speak to and to turn the pages of and read what is intended by the lawmakers.
So how matters of the Constitution get sorted out in a place like that, when you don't have a written constitution? The
beauty of a written constitution is there is a written word that you can turn to, like we have in Trinidad and Tobago. The thing with the British is they have had jurisprudence that stems hundreds of years, that is built on the Magna Carta, that is built on the Bill of Rights, and tradition. Sometimes tradition and convention counts a lot more than what is simply written in language that like we have in Trinidad and Tobago.
Yeah, so it's the same thing when somebody talks about what is settled law. So after a period of time, it may be decades, it may be centuries, when something becomes the custom, that stands.
Exactly. The advantage is that with the advent of time, with the advent of decades, with change of times and change of ideological positions. For instance, we live in a society now where issues of gender inclusivity involving men and women and persons who don't identify as men and women, that is something that we are contending with because we are bound to a constitution that doesn't cater for certain things. Whereas with the British, they don't have a constitution, so as a society, their society has evolved. They are in a better position to adapt and change laws and regulations without being bound and binded by a constitution that speaks to what specific norms and ought to be.
Yeah, well, I'm glad you raised the issue about gender, and I would call it gender orientation, because one sees that will come as an issue that will challenge people's sort of the extent to which people may not be able to get in certain positions, fill certain positions because of their gender orientation, or in some cases you might say their gender choice. I'm not sure to what extent it's its choice or that is just how people are. So that is a whole avenue waiting to be walked as we go through this question of what is constitutional and what is not.
If we were to make a projection in terms of, or project our minds in the direction of where the possibilities are, given that is a current issue, and it's a generic change that we're all dealing with at this point in time in terms of it, or persons in that category seeking some level of equality, then it is only a matter of time for someone in Trinidad and Tobago who perhaps is of that inclination to raise an issue before the court in the same way that Jason Jones raised an issue when he took umbrage with the section, that particular section that speaks to buggery under the Sexual Offences Act. So who knows? Challenges as it speaks to entry into certain key sectors and government jobs and public jobs may soon come by persons of that inclination if they feel discriminated against. But the courts can only treat with issues as they arise, meaning that someone has to bring the issue before the court can treat with it. The court cannot go on a sweeping mission to weed out all the issues or all the challenges in advance of them. A problem has to present itself. Yeah. So once it is raised, then the court will be forced to lend its voice.
Right, and so let's look at an administration in office as well. So they don't have to, or there's no obligation under any administration to go and pick out a set of things and say, well, look, before we get in trouble here, we just put these things as not against the rules, against practice, so we could hire people on the basis of irrespective of their personal decisions regarding sex and gender and what have you.
As it stands now, administration would not go nitpicking on issues or anticipating a problem to try to correct it. That there is a way to do that if it is an administration embarks on what we call constitutional reform. If you embark on constitutional reform, you may look at your constitution, and this is something that we may be confounded with in Trinidad and Tobago at some point, if not already. We may look at the constitution and say this constitution that we have was written in a time, in an era, 1962 to 1976, because our constitution right now is as old as 1976. It was enacted into being then. If our lawmakers and our parliamentarians look at the legislation and say, or look at the document, the constitution, and say, this clearly was scribed in a time when social norms and practices and what was considered lawful and unlawful and what was considered proper and normal now belongs to a bygone era, they can look at it and say, well, perhaps we should embark on changes, though not whole-scale changes, but sectional changes where they address certain sections. Yeah. But that would require majorities and a coming together and a unity within the parliament.
That we don't have now.
That we don't have now at all.
Yes. 76, that's because that's when we became a republic.
That's when we became a republic.
It had to be a republican constitution.
Right. And that constitution came into effect in August of 1976, which is in reality 48 years now.
Well, let me just read this piece from the newspapers on that here, that paragraph. Under Section 6 of the current Constitution, legislation which is found to breach citizens' fundamental rights cannot be challenged if passed before the country's Constitution was amended in 1976.
Right.
So anything that escaped that, it can't be tampered with now.
It can be tampered with, but it will require certain majorities. Now, allow me to develop the point along these lines.
Go ahead.
When we, as a nation, scribed the Constitution into being, which is the Republican Constitution of 1976 into being, there would have been laws that pre-existed, meaning pre-existed that period of August 1976. If it is those laws were repealed, what would have happened is a certain level of anarchy would set in, meaning that imagine you wake up one morning, August 1976, with the enactment of the 1976 Constitution, and everything that was law yesterday is no longer law. So persons who stood before the court or who are sitting in the nation's jail find themselves in a position where what was wrong yesterday isn't wrong today, or what was against the Constitution yesterday isn't against the Constitution today. So you would find challenges, you would have constitutional challenges now. That may arise thereafter. And imagine you multiply that by the hundreds or thousands of persons sitting in the jail. Or you would have people who would have had grouses in terms of they were of the view that there were industrial relations practices that went against their religious belief. There were practices that speak to how one lives one's life that the Constitution would have spoken to. But today, that has now become old law. So that sort of anarchy, the law requires consistency. An individual must know exactly what the law is and in what way I could infringe the law and in what way I have infringed the law. So they could not have treated everything that happened before the enactment of the 76 Constitution as repealed or non-existent.
I'm glad we go there,
right.
Because I want to raise this matter. It just came to my mind as you were talking about it. You know, it re-entered my consciousness. The question of a couple of weeks ago, was it, or a couple of months ago, we had this issue about this guy who was on death row with another fellow for having committed a murder, and he said that well, it was reported that he'd had his last, would you call it, last rites read to him on at least 2 occasions. He was expected to go before the gallows, but it didn't happen, and that he would put in a cell where he could have heard when people got executed, and those things were talked about in a kind of way as though some of his rights were violated. To what extent something like that would have gone in his favor, and therefore he could avoid the hangman because of what was seen to have been I'm not even sure the term, improper treatment of him in prison. He's convicted, he's sentenced to death. He was called up one time, the last rites were read to him, but he didn't go through. And he said he stayed in a cell close enough to hear when people were getting hanged. And that seemed to have, it could work in his favor. Let's talk a little bit about that.
Well, if we look to examine the example as you gave it, one has to bear in mind, and the public needs to bear in mind, that the issue of hanging, that comes under a colonial law. So it's what we call an existing law that we inherited. We cannot now go and revoke or remove that unless it is we get certain majorities in Parliament to remove the penalty for murder, which is hanging, death by hanging. Now, as it speaks to the example, if an individual is charged before the court, when he's charged and he's brought before the court, he ought to be informed as to in what law did he breach that requires him to answer to a court and that requires him to retain an attorney to defend this position. In other words, you can't defend or properly form a defense if you don't know what the proper charges are against you and what way you contravene the law. Now, an individual under Section 5 of our Constitution has the right to know what the charge is, the right to representation, and the right to be able to put his defense. That all comes under the rubric of one having a fair trial. Now, if it is that death warrant was read to an individual, meaning that it was read to you on 2 occasions that you will be hung and that you are awaiting the hangman's noose, it is cruel and unjust if it is a 5-year period has passed whilst one is waiting in remand for that process to take place. And it's inhumane to have an individual sitting with the suspense of knowing that any day now the hangman could come or they can read the death warrant to me and I could be hung. If it's not done in a reasonably quick time, meaning that promptly, then that in itself is mental torture and emotional torture that impacts upon the psychology of the individual. The penalty for murder is death. It's not death by torture, or it's not torture and death. So if you have breached the law and the court has held that you are in breach of the law and therefore ought to be hung, then that hanging process ought to take place without delay, with quick dispatch. Yeah. So the psychology of knowing and hearing persons dying and hearing the cry and so on, that is something that he ought not to have been subject to. Yeah. That isn't part of his stay in prison. Yeah. In fact, he ought to be housed in a place different from where the hangings are taking place.
Know, when thinking about it, I wondered to what extent the prison authorities did that, knowing they weren't going to go through with it, and that this will redound to the favor of the person. But that's another discussion altogether. Yeah. But let's talk about this particular case in which the youngster who didn't make it on the list in the police service because of his height, and the Minister of National Security has said that the government is thinking about appealing that.
Right. What we need to be
when it shows that it raises the question of his constitutional rights, and it is said to have been ultra-vires the Constitution, but the administration is talking about appealing the decision on that issue to say that it is unconstitutional.
Clearly, Justice Robin Mohammed thinks differently. When we examine the ruling, and the individual who raised the question before the court is one Ronaldo Mirage. When Mirage raised the issue of his height being discriminatory being a discriminatory issue. And in other words, you can't use someone's biological position against someone or against one in relation to one's eligibility to something.
But it used to be the case, right? It used to, you had to have a whole set of physical attributes.
Yeah.
As we were talking before we came on the air about being flat-footed,
right,
and those kinds of, I've heard those kinds of things where, so you didn't measure up because you're not tall enough, you're not robust enough, you're flat-footed and so on. Those things have gone out the window.
That sort of narrative existed under colonial times. It was a narrative that tall men of a certain build, a certain physique, a certain brawn, they might be in a better position to restrain and constrain and suspects and unruly persons and to enforce the law. But experts have looked at it, and within the affidavits that were brought before the court, references were made, and Dr. Jack Dew he offered evidence and said that there's no evidence that speaks to a short man not being able to equally enforce the law by way of using his strength and his brawn. In other words, a physical fitness test might be more suited than a test as it speaks to one's height. It's almost as if you're stereotyping that taller men are stronger men and taller men are more virile as opposed to younger men. And younger men are less inclined to be able to enforce the law and to impose themselves on threats to themselves.
I'm talking about height because the Minister of National Security also said, he was heard to say that, well, we need police officers to see the people in a crowd. So we want to...
Well, what if it used to see the person in the crowd, but when confronting the person that you're seeing breaking the law, you don't have the physical attributes to constrain him? Whereas we live in an era now where persons are trained in self-defense tactics, in karate, in taekwondo, in different skill sets that involve self-defense. If you have a short man with that skill set, and you have a tall man who doesn't have it, all he has is his physique. That doesn't mean to say that he has the ability to restrain somebody who is taller than him or equal in measure. But what we saw is, pre-existing the 1976 Constitution, was that discriminatory clause that speaks to one must be of a certain height. What makes it borders on ridiculous in terms of the exploration of the judgment and the evidence presented in the courtroom was the judge was saying, so then why have a lower threshold for women? Shorter women can join the service, but taller men.
Yeah, so if a man who is the same height with a woman has a disadvantage, but whereas she could get in, he can't get in because he's a man and they have the same.
Right, and basically what the court is saying is that, and their functions, the male, the officer, and the female officer, their function is the same. The female officer has to go out there and use her strength and use her height to her advantage.
And increasingly, run down people like anybody else.
Like anyone else. But in terms of the ruling was an issue of dealing with the savings clause, which is Section 6 of the Constitution
of the Republican Constitution.
Right. Section 6 speaks to the fact that any law that predated the existing Constitution is transferred into this Constitution, is treated as existent. Now, the court can in instances repeal that law, but if they're repealing it, it can be reapplied, meaning that you can repeal it and bring it back into existence by reenacting it right away. So you can repeal it on the 1st of August, and then when you enact the 76th Constitution on the 2nd of August, then you bring it back into life. In other words, it's repealed and it's reinstated in the same transaction.
And there have been pieces of legislation which went through that process.
There have been pieces that went through that process, but there is another section of Section 6 that says, if it is you repeal a law, but you bring it back into existence in the same state and the same condition that it was in. In other words, the height requirement was a typical example of that, and that is what saved it on some level. The height requirement was lowered when the Constitution was formed, meaning that it was lowered in the sense that more men could get in and more women could get in, but the threshold for women was sufficiently lowered that more women could get in ahead of men.
Yeah.
So it was disproportionate where the change that existed, the change that existed allowed for more women to get in disproportionately in relation to men. And that is the issue that the court ruled on. It's saying that technically speaking, when we look at the nuance, when we look at the law that was repealed and the law that came into existence, meaning the police service regulation as it existed in 1965,
right,
pre the 76 Constitution, and the regulation that came into being in 2007, post the Constitution,
yeah,
that regulation significantly lowered the threshold. So therefore,
for entry.
Therefore, the existing law was not saved.
All right. Okay, so I want to get to the stuff of the beard stuff and the prisons officer, but just before you go there, just quickly, well, one, I'm not sure what is the basis on which attorneys like yourself will refuse a brief, but if the government is saying it will challenge this decision, is that worthwhile? I mean, what are they seeking to do to remain in that age rather than face the reality that you can't deny somebody entry into the service on the question of height?
The government is saying it wants to challenge the decision as it relates to height.
You think they will?
The thing is, the challenge has to be a challenge grounded in law. Clearly, if it is the government is of the view that height is a necessary prerequisite, one must be of a certain height and certain brawn and certain build, then they must scientifically provide evidence to prove that. There were two witnesses that offered evidence, expert evidence in this matter, and the two witnesses, one for the state and one for the applicant in terms of Rinaldo Mirage. The applicant's attorney, Dr. Jack Dew, indicated there is scientific evidence to show that shorter persons have a lower sense of gravity, so they may be in a stronger position to defend oneself. Whereas with regard to the state, their expert, Sumeserari, he indicated that he provided no scientific basis for stating that taller persons have commanding advantage because of their height. He simply stated that our standard of height standard is in keeping with international standards. In other words, when we look at Barbados, Jamaica, St. Vincent, Grenada, there's a height stipulation. But
because
when
their constitution doesn't prevent that.
Their constitution supports you must be of a certain height, right? So Sumesa Rai is alluding to the fact that when we look at our Caribbean neighbors, we are putting into practice laws that they have in place. But that in itself, according to the judge, that in itself isn't a scientific formatting. It could mean that they are just as wrong.
Yeah, as
right?
we are.
So you can't say because everybody else doing it, well, we're doing it.
All right, so let's get to the beard thing then, because in my own construct, I say, okay, so a beard such as what you're wearing now, we could say that is fine, but it was a time when you couldn't just wear any beard you want. So okay, so you might be a Haji in the prison service, and you want to grow your beard down to the middle of your chest, and you can't do that. But this ruling is saying that you can, because it is against the Constitution to say that if you're going to wear a beard, it has to be a certain style.
This ruling actually did the reverse of what happened with regard to the height stipulation. In the height stipulation, the law was not saved, and therefore the court ruled that height is no longer a requirement in terms of entry into the service, and it asked the service to re-evaluate its position in taking in persons and denying them on the basis of height. With regard to beard, the reverse took place. It simply indicated that existent in the Police Service Ordinances of 1965 and compared to the Police Service Act of 1971 and 2006, that the issue of one having to wear a beard of a certain standing, meaning that you only allowed to wear a mustache with no handles, meaning no sideburns. So somebody like myself with sideburns, I certainly would have to shave. I would be ineligible if I intend to enter the service like that. You're only entitled to have a mustache, no lower beard below the lip, and no chin, and no sideburns. So the law speaks to one looking smartly dressed.
You mean that exists?
That is the
what
existing law right now.
In the police service? Or?
In the police service.
Yeah.
So, and
what about in the prisons where this gentleman?
Well, this ruling was, in fact, I mean, to be correct, the ruling was, both of them were police service ruling in terms of the beard and so what was challenged is the police service, is in both of them, Christian Khan is beard in relation to the police service and the height in relation to the police service.
Right.
There wasn't a prison officer ruling as yet. Now, where we are with the situation with the beard is, again, we come to the existing law, the Savings Clause. The Savings Clause, Section 6, raises its head again in our Constitution because we have that Section 6 of our Constitution that speaks to all the existing laws that existed in pre-colonial times. And this issue of the beard, not having a beard, only being allowed to grow a mustache, that existed under colonial times. That existing law was married into the Constitution of Trinidad and Tobago, and it was never changed. Why it is it remains the same, and as we speak now, the court's ruling, Justice Lambert Peterson ruled that the beard stipulant or component remains. It's simply because we are constitutionally bound to carry that archaic law or carry that law into our books because our Constitution simply makes allowances for it, and until there's constitutional change, we cannot in any way remove this.
Right, because I presume that there was a period in those times, colonial times and so on, when if you had a choice between being a Maulana or a Haji and so on, you have to be consistent with what that calls for, and therefore you would not even think about joining one of these agencies, these state agencies, certainly in prisons and so on. But now that you can't be overruled or you can't be denied entry, and you want to maintain your religious rights as you see them. Because
Right.
this is what this is saying.
In other words, it is discriminatory on the surface of it, but the court is hamstrung in making a decision that allows for a Muslim with full beard to enter the service because the Constitution prevents it from acting. A court.
So as we speak right now, in this case, Mr. Ashad saying he faces a challenge because of the system that he.
Well, let me put it this way. The ruling that I was looking at is one by Christian Khan, right? He's a police officer who attempted to grow a beard. Yeah. Now, the issue is simply this. This officer will not be able to remain in the service if he wants to grow a beard. Now, it means to say any Islamic individual, any person who is trying to enter the service with a beard will be prevented from doing so because that individual is bound by existing law. We constitutionally will have to change the Constitution, which allows for the Police Service Regulation, Section 3, Subsection 1 to be changed. Because we inherited the ordinance from existing law, and the beard component existed in the ordinance, meaning the colonial ordinance, and it was transposed into our Constitution, then we cannot change it, and the court cannot rule. The court is a creature of statute. The court could only interpret what the law says.
Yeah, but this is the story saying that High Court Judge Margaret Mohammed issued a declaration yesterday upholding a constitutional lawsuit brought by Ashad Singh, and the story begins by saying that a TNT prison service policy barring Muslim prison officers from keeping beards has been deemed unconstitutional.
That is an issue we need to explore. The one with regard to the police service clearly is inconsistent with regard to the prison service. Now, I'm in agreement that on the face and the surface of it, it does discriminate against persons of a certain religious persuasion. Now that we have two conflicting rulings, meaning the court, as it speaks to police officers, they can't enter with a beard, and we have a prison office, the prison service, where they are being allowed to enter with a beard, it means to say there will be another challenge, because that now serves as a judicial precedent that may hamstring other applicants who's applying to get into the police service. So we may see now the floodgates opening up as a result of that ruling with regard to prison officers.
That's a good thing. At least judicially, we are moving into a more sort of accommodating
Well, it's
setting
all
as well?
part of the efflorescence of change, and it's all part of the nuances that come with changing society and evolving times. We ought to see that the law becomes mindful that society isn't what it was in pre-colonial times or in recent times. And if it is, one is to look at it from a scientific point of view. A man with a beard might be a more able, capable officer because of his mental strength and because of his intellectual capacity. It has nothing to do with one's physical looks. So we may, who knows, we may see a Rastafarian police officer in time to come.
In time to come. Thank you very much, my friend, Farid Ali. This has been 10 Questions. I'm Andy Johnson. Thanks for watching. We see you next time.
WESN.
Hello there and welcome to AM Prime on WESN Content Capital. Before we even start this repatriation and reintegration process, we've already failed, or are we doomed to fail?
You've got to invest in the institutions that you've established to carry out those sorts of core functions.
We now get into the regional updates to give you an understanding of what's happening across our neighboring islands.
We have available a number of films that are worth showing.
So it was day one when the French Revolution started to develop the concept of universal human rights.
What happened this time is unprecedented. It's one of the largest terrorist attacks in history.
Let's welcome Carl to the program. Carl is over there next to Steph. Hello, Carl.
Silky anteater or pygmy anteater, and we have 2 of the 3 species of anteaters right here.
My name is Carl Media, and I'm the founder and the host of Ever Increasing Voice Ministries. Join me every Saturday and Sunday